Substandard, abhorrent, and likely unlawful. That is how a U.S. district judge described the conditions of a cramped Long Island ICE holding room. Federal Judge Gary Brown, a Trump appointee, is threatening to hold the Department of Homeland Security in contempt for refusing to provide photographs of the facility and submitting false or evasive documentation about detainees. The ruling stems from a petition filed by Erin Carr, a Jamaican national who overstayed a visa but was pursuing legal permanent residency through marriage. The judge found Clark's confinement in filthy, overcrowded, and unheated conditions violated constitutional due process. Joining us live tonight is Assistant Professor of Law at Seattle University, Erin Carr. Erin, thanks for being with us.
Good evening, Joyce.
This case identified this incident as part of a national pattern of inhumane care. Do you see this setting a precedent possibly for judicial enforcement against DHS or ICE?
Well, I think it's noticeable that the judicial findings in this particular decision are consistent with systemic abuses in ICE detention facilities nationwide that have been documented by journalists, human rights organizations, other courts, and even bipartisan congressional investigations. In ICE detention facilities across the country, including at the Northwest Processing Center in Washington, thousands of immigrants, the majority of whom have no criminal history, are routinely held in unsanitary conditions, sometimes for years, without access to basic medical care, adequate food or water, or legal assistance. And just last week, in fact, Amnesty International released a report documenting abusive conditions at 2 Florida immigration facilities, including a detention center in the Everglades that government officials have proudly dubbed alligator Alcatraz, where people in those facilities, including pregnant women who have miscarried because of medical neglect, are housed in literal cages with overflowing sewage. Some of these ICE detention centers have been ordered shut down because the conditions are so appalling. And yet, because the Trump administration is in need of additional space to house a record 65,000 people currently in immigration detention, the government is now hastily moving to reopen many of those shuttered facilities.
So what are some of the mechanisms that could strengthen constitutional oversight at a federal level?
Well, the due process failures and generally inhumane conditions in ICE detention centers are far from new, but they are rapidly becoming more dire as the government detains a record number of people, exceeding the capacity of already overcrowded and understaffed facilities. What we are seeing is that at virtually every stage of the immigration process, due process protections have been eroded or simply disregarded. Now, Congress has a constitutional as well as a moral obligation to provide adequate oversight of immigration enforcement. And disappointingly, congressional leaders have largely abdicated that oversight responsibility. And for those federal legislators who are attempting to address the issue, they have been actively obstructed by the Trump administration, which earlier this year began restricting lawmakers' ability to access immigration facilities to conduct oversight visits.
What could this ruling mean locally for ICE detention practices and oversight? And I'm just thinking about the people, some of our viewers who might have family members in detention right now, or they know someone who's being held in detention. Could this ruling impact our facility locally at all?
This decision, because it's based in another jurisdiction and it's not a national class action lawsuit, won't have a direct impact on the equally concerning conditions at the Northwest Processing Center, but it may further galvanize local and state leaders to demand that the federal government and the for-profit company that earns millions of dollars a year running the facility meet their legal obligations and provide minimally acceptable care to the people in their custody. Earlier this week, several Washington legislators did just that. sending a letter to the acting ICE director to express their concerns and demand immediate action regarding the unacceptable conditions at the facility.
And then finally, if DHS or ICE are actually found to be in contempt, what would be the ripple effects of that?
Well, a contempt finding would be symbolically significant, but it may have little practical effect in incentivizing the government to comply with the law. The Trump administration has been repeatedly accused of disregarding federal court orders in other cases, including in the case of Kilmar Abrego Garcia. And several other judges have already threatened to hold the administration in contempt for disregarding their court orders. I should note that any contempt order issued against ICE or DHS would most certainly be appealed, and contempt orders against the government are generally not upheld on appeal.
Erin Carr from Seatte University, thank you so much for being with us tonight. We appreciate it.
Have a great evening, Joyce.
You too. Happy holidays.